and I can keep an eye on things until you get back from helping folks.
You are a co-host.
Okay.
Tanya, I just emailed you that link. This is Jason. I did the invite and emailed you the link, Tanya.
Okay, the recording's going, so unless there's something else of needing done, I'll get cranked up here and get started. And start off by welcoming everybody. Glad to see y'all here. I had a special request yesterday to speak briefly about the law enforcement officers. I'm assuming all of you are probably aware of what happened to Beth Maggioroni. And so for those of you who saw the chairman order the officers to remove her, the officers responded, and probably not in the most professional manner, removed her from the meeting. Now, there is a problem for those law enforcement officers. All law enforcement officers, just like those of us who are in the military, we have a standing order that we will obey every lawful order sent, handed, or communicated to us. You have no duty under the Constitution to obey an unlawful order. Number one. Number two, because of your oath of office, a law enforcement officer may not take any action which violates Article 1, Section 1, Paragraph 2. They have a duty to protect, a constitutional duty to protect the person and the property of everybody they come into contact with in this state. So you ask yourselves, what in the world does a law enforcement officer do when he knows he's in that place to help preserve order, and that the chairman has the presumptive authority, pay attention to that word presumptive, to maintain order? Well, in that case, with Ms. Maggioroni, whoever the senior officer was in charge of that detail should have walked calmly over to the chairman, leaned over, and whispered in his ear, if you give that order publicly one more time, I am going to put you in handcuffs and I am going to book you in on a federal charge. That way, those officers today would not be facing two potential federal criminal prosecutions and a federal lawsuit in tort. And the county of Chatham would be infinitely richer, depending upon what a trial jury would award in damages. Now, can we blame the officers? Well, yes, we can, because their oath of office also requires them to be knowledgeable of the law, which, as I think you ladies and gentlemen, and I covered back in the beginning of this session about Title I, says specifically that when laws become effective, it is the duty of all persons to take notice thereof. Ignorance of the law excuses no one. So, yes, those officers had a duty of their own to know. But we cannot put the burden entirely upon the officers because of their day-to-day activities, which consumes a great amount of their time, and sometimes even more time on duty than sometimes they're compensated for. So who else can be charged with having a responsibility? And that gets back to the police chief. Actually, it gets back to several individuals. It gets back to those who have the administrative authority in the organization. And this has to do with both police chiefs and police officers and GBI and FBI. But whoever's in charge of training needs to see that those people get the necessary training. Whoever has supervisory or managerial oversight of that training officer, which is usually the police chief or the sheriff, they need to ensure that those training scenarios are available in their department and ensure that the men and women under their command are trained. So there's a lot of blame to go around for what happened, but it also can be ignored that the individual primarily responsible for that scenario was or is currently, don't know how long he's going to be in these positions, but he is currently an attorney. So he's looking at a bar complaint, and he's also a city judge for the little community of Thunderbolt. And that may be a position that's about to leave. So just so you understand why law enforcement officers can wind up being in trouble for doing what they're told, that I hope will help explain to you why it is in this republic that even the lower echelon people in an organizational structure can be held liable, both criminally and civilly. Now, keep in mind this concept of pleading, oh, I was just obeying orders. That doesn't cut it, ladies and gentlemen. That has not cut it since before the Nuremberg trials. All of the Nazi officers that wound up adorning the end of a rope, that was their main defense. I was following orders. And it didn't cut it at Nuremberg, and it sure as heck don't cut it in this republic. And I thank you for letting me, I hope that answered the young lady's question who asked for that explanation. Now then, we're still, we're not making a whole lot of progress here. What started out as 6 weeks is.
Oh, Judge, I have a question or comment.
Yes, ma'am, far away.
Yes, well, I was there and they also violated my rights. So you were talking about chaos. They're supposed to maintain order. Well, there was, after Ms. Beth was transported, but she was at the doorway. She was still inside discussing with the police. There was all this chaos. Everybody was looking over there, so they didn't notice. Then Mr. Mahoney starts mumbling from his desk about, he's somehow explaining, and there is a video of this, he's somehow excusing himself why Miss Beth had to be thrown out. But the podium, I was sitting right between the podium and him, so I couldn't hear him. So I stood up to read his lips, because that helps me a lot. And this facility had no accommodations for ADA or the deaf. I almost tripped over the doorstep. And it was not an auditorium. It's where people go and vote on voting day. And no microphones for the speakers or anything. I'm not sure if Mahoney even had a mic. And so I'm standing up to read his lips, and he keeps saying, sit down, sit down. And I keep saying, but I can't hear you. I have to read your lips. And then he ordered me out of the room and sent this threatening police officer with a mean look. So I didn't want to be manhandled like Miss Beth. So I went peacefully. I took my stuff and I went out. But this was completely illegal as well. I didn't get the officers' badge numbers, but Beth has them apparently. And I'm calling tomorrow. Now this is Chatham County Police. It's not the sheriff.
Yes,
and I don't know why this is legal. They're sort of like glorified mall cops.
But it is
And
not.
I don't know what it is, but anyhow, so I'm gonna call this professional conduct Sergeant Sladen tomorrow and file a formal complaint against these officers. And apparently they called the supervisor on duty, so him too, because he should have told them what to do. And but I think these people, and then when I got home, I was fearful. I kept thinking the police are gonna come to my door. It was absolutely an unreasonable fear. The police weren't gonna come to my door, but this is what happens with tyranny. This is how they enforce fear. You don't want to be embarrassed. You don't want to be on TV. You don't want your picture all over the internet. It doesn't matter if you were in the right. This is how this tyrannical governments enforce fear. So, well, that's what I just wanted to say about this,
Yes, ma'am. And let me suggest that you get in touch with Beth, let her know that you received a threat from the chair. And
Mhm.
you would also like to speak with the attorneys with whom she's speaking. And let her transfer your information to them so they can get in touch with you. Or you can get in touch with them, just in case you want to consider some action other than written complaints with the Chatham County Police Department. Because
Well, the
yes,
last time I talked to her, she's still shaken. And this is PTSD,
yes, ma'am.
and this, none of you here have ever been picked up by the police, and we're all law-abiding citizens, And this is like they do in communist China, where they pick people up like that. But but she last time I talked to her, she had not decided on which lawyer, and she spoke on voter GA yesterday, and she told them she hadn't decided what to do yet. But she's still visibly shaken.
Well, see, as far as I know, nobody knows about your situation, that you were also forced out, ordered out. So that needs to also be made a part of this.
Yes, sir.
Because now he's looking not at one bar complaint and one JQC complaint. Now he's looking at two and possibly a second federal tort action. Not to mention a violation of the 14th Amendment, Section 1, Clause 2, which is also criminally prosecutable under 18 U.S.C. 241 and 242. So, this is one of those times when a politician, and I'm quite sure all he was trying to do was to protect Mr. Wooten's reputation, or at worst, he was trying to keep the public from finding out that there had been a grand jury inquiry into the Board of Elections. And either way, he went too far. He crossed the line from civility into a tyrannical conduct. So, yes, you do need to let your story also be known. Now, I'm quite sure you may be hesitant about, like you said, getting your picture plastered all over the internet and all over the Rumble and some of these others, but grin and bear it is all I can recommend to you right now. And do consider your complaints with the bar and with the JQC, and also discuss with attorneys the evidence that you could have going into your consideration of a tort action.
Well, as far as the bar complaint, I'd like to know the Georgia election law, all the parts of the Georgia election law that this Chatham board is breaking, because they're saying that we don't have the right to have monthly meetings or periodic meeting and to address this board. They're saying we were just so lucky that they allowed us here. That was his whole attitude. I don't know if there is a tape of the whole thing. And there is a video of, like, you can hear my voice saying, please, can I read your lips? I can't hear you. And he could have said, come forward and sit right in front of me, or I'll speak louder. He could have said, he didn't say, I'm sorry. Usually when I say I can't hear you, people say I'm sorry. But this is how this mentality of this guy. And, but I'd like to know all the laws he broke for my bar complaint,
So it's something that perhaps we could discuss after, so that we can get through the discussion
Right.
of the Constitution today, and you
Yeah.
guys can talk further and discuss.
Yeah,
maybe
that's
after,
fine.
out of respect for everybody's time. Thank you.
Okay,
Okay,
Oh.
thanks.
yes, ma'am. Now, getting back to the Constitution, I think I had promised y'all last time a little bit of humor. But as part of that, I would like to use this opportunity to help you understand that when it comes to statutes and provisions of charters, it's always a good idea to have a sound understanding of the entire document. And the reason for that is because sometimes there are situations that can come up, and the situation may pointedly address one particular provision of that document. But it is also probable that there is some other provision that addresses or modifies what the first provision addressed, or the manner in which the first provision addressed that issue. And as an example, today, I'm going to bring your attention to the Georgia Criminal Code 16-6-20, which is Georgia's bigamy statute. And Georgia plainly says that a person commits the offense of bigamy when he or she, being married and knowing that his lawful spouse is living, marries another person or carries on a cohabitation with another person, a bigamous cohabitation with another person. Now, all of us can agree that it is a crime to engage in an act of bigamy. Well, what is bigamy? Well, bigamy is the crime of bigamy is the criminalization of a breach of a special contract. And if you want to know what that contract is, you can go to your copy of the Constitution and run down to Article 1, Section 4. And there is where your legislature has, at the insistence of the people, everybody in this state, told the legislators, put this language in a amendment form and put it on the ballot so we can vote for it. And this paragraph 1 under Section 4 is what the citizens mandated be in the Constitution when it comes to marriage. And it says the state shall recognize as marriage only the union of man and woman. Now, we don't need to go any further. Just that alone, that language needs to be clearly understood. And the language in specific that is specific here is man and woman. That phrase does not address a numeric value. That addresses gender. In other words, they could have substituted male and female and said the same thing. So right off the bat, our Constitution does not prohibit polygamy. But by the same token, it doesn't prohibit polyandry either. Now, why would that be? Why would they use a gender phrase instead of saying as a union between one man and one woman? Why didn't they say that? Well, the simple reason for that is you have to go back to the individual rights, privileges, and immunities that are guaranteed in Article 1, Section 1 of our Constitution. And when you start reading that, you get down to paragraph number 9, and oh, that says the people have the right to assemble peaceably for their common good. Well, for their common good just happens to include the institution of marriage. And that paragraph does not limit the number of persons who may legally, peaceably assemble. So I hope you're beginning to, oh, and by the way, for those of you who may not know, polyandry is where a female can marry as many males as agree to such an arrangement. And the same goes for polygamy. But this is an illustration of why you need to not just read one provision in a statute or in a constitutional provision and say, well, now I understand, because you may not understand. There may be other provisions that dwell on this problem. So that may not be the most comfortable analogy of the situation, but I'm just throwing that in there so to help you understand. And by the way, I would make this point too, especially to the gentleman in the audience, and that is if you guys are ever out with your wife and she runs into somebody she knows and she's talking to them and she realizes you don't know them, and she turns to introduce you and says, oh, and by the way, let me introduce you to my first husband. Boys, you may have a problem. So anyway, now where in the Sam Hill did I get off to? Things sure are quiet.
Hello, Judge.
Can you
We're
still
all muted, Judge.
hear me?
Yeah, we can. We're
Okay.
just all muted so that there's no background noise when you
Oh.
speak.
Oh, okay. Oh, I got you. All righty. Okay, now let's go ahead and jump. Y'all can fight your way through the rest of the Article 1. Except for paragraph 29. Please pay attention to that one, because there are, and the courts have held this, by the way, the federal and the state courts, that is referred to as the prior rights provision. And what that basically means is that the enumerations prior to that of protected rights, privileges, and immunities are not exclusive. There are other things. For example, your right to privacy is not mentioned either in the federal or the state constitution, but it is covered under paragraph 29 as a prior right. And of course, there are others of probably diminishing values as we go through them, but they are still likewise protected. So anyway, now we're going to move along to the structure of government, to our section 2. Now, I think we mentioned in the first time we got together that the Constitution is a charter, and that charter was reached because in the 13 colonies, there were approximately, give or take, 3 million citizens who all agreed and let their individual states representatives and senators know that they wanted a constitution. And so that in effect was a form of contracting when all those people got together and said, yeah, we want to do this. So they all agreed. And from that agreement came the Constitution, which is in fact a charter. Now, yes, it does contain language that seems to sound in contract, and actually it does. But generally speaking of the Constitution, it is simply a charter wherein the sovereigns, that is the citizens, every individual citizen was a sovereign at that time. And they agreed we need a constitution to organize the structure that is going to govern us and help ensure our peace and domestic tranquility, and possibly our fortunes as well. So to get this charter, this constitution, each individual sovereign in the state, in each of the states, gave up a small piece of their sovereignty, all of them giving up the same piece, the right to enforce law. For example, protecting your property or protecting your home. That is police power. All of it is yours when you're a sovereign. The whole burden is yours. But when you contract with one of your neighbors or all of your neighbors, and you all develop a charter to organize a structure that can handle more effectively the police power that belongs to each of you, then you give up a little bit of that to the government. Now, it just so happens, now we're going to talk about, here's another example, something that y'all need to know. Talking about police power. All of you have heard, and because the newspapers published it, the TV stations reported it, oh, the state of Georgia has repealed citizens arrest. Well, I got a news flash for you folks. Your legislature did not repeal citizens arrest. You still got it. The reason that you still have it is because in contract law, and I'm talking about contract law that existed from the common law till today, in order for a right to be eliminated, completely done away with, nobody can use it ever again. For that to happen, there must be in writing a document which clearly states that this particular right shall no longer be valid, enforceable, usable, or some words to that effect. And no such document existed in the legislation that was used to change the verbiage of 17-4-60, which was the citizen's arrest provision. That in contract law is called specific repealer. And in contract law, for a right, privilege, or immunity to disappear, never be used again, there must be a specific repealer. And the legislature did not do it. By the way, specific repealer is a process you will find in Title I. So, you know, I hope none of you ever have to use citizen's arrest, but if you do, just know that you still got it. Even though, you know, cops will come up to you and say, no, you couldn't arrest that individual. Well, I did. He's under arrest. He's in handcuffs. Now, your duty under the law is to transport him and me and see that I get there to a judge for a probable cause hearing right now. Don't go to the jail to book him in. Go straight to a judge. That's the law. But, you know, just tell him, I'm not going to argue with you about police authority and me still having the right of arrest. Just take this individual, let's go see the judge, and then you can take him book in. And, you know, if you don't like it, you can always sue me. But the courts will agree that you still have the right until such time as your legislature enacts a specific repeal. And so to help you understand this paragraph 1, the origin and foundation of government, and it being originating with the people and founded upon their will, it is true that it is instituted for the good of everybody. As it says here, it shall be instituted solely for the good of the whole. But one thing you have to remember is that every right, privilege, and immunity is focused upon you, the individual. The protections of this document belong to you, the individual. And that is why a lot of people can say, who study law and stuff like this, they can say, well, yeah, it's for the protection of everybody. But you got to understand that when you protect one citizen, you are in fact protecting them all. Now, this next, in this paragraph 1, this next sentence, this holds a considerable amount of meaning for y'all, and we're not going to go into it right now. But it deals with what are your rights against if you have to go against a public official. What are your rights? Well, to know that, you need to know what legal status your public officials have. And this says very plain, public officers are the trustees and servants of the people and are at all times amiable to them. Well, we just got through discussing what happened to what a public officer, a trustee, and a servant of Beth Maggioroni did to her. What about board meetings that y'all go to? And everybody there, as a matter of fact, the vast majority of everybody in the county wants a thing done a specific way, and the board refuses to do it. What are the legal consequences? Well, that's where you go down to in the Title 50, about 50, Title 50, I think it's Title 51 or 52 or 3, somewhere around in there. It's wills, trade, trusts, and estates. And find out what the liabilities of trustees and contracted servants require. That's where you'll find the law that will tell you how to handle errant trustees. As a matter of fact, and this is a neat idea. One of the things you can do. Now, I'm sure that most of you have heard stories, or you may have actually experienced going into a court, and it doesn't matter, magistrate court, superior court, whatever, or court of appeals. You go into court on some kind of a disagreement, and you see a judge use rules of practice and procedure, but he uses them the wrong way, or he uses the wrong rule of practice and procedure. And you wind up, or some poor other soul that you're watching winds up losing his case when he should have actually won the case. What can you do? Let me give you a suggestion of something you can do if you're ever hauled into court. You can draw up a document, or you can get a lawyer to draw it up. And it is known as a notice of acceptance. And what that does, if you go get a judge or a sheriff's or a district attorney's oath of office, and you draw up a notice of acceptance, and you staple that oath of office to the back of that notice, and you sign that notice, what you're doing is you're telling that public officer, you have placed into the public domain your promise in this oath that you have signed to do a thing for compensation to my benefit. And I am accepting your oath, and therefore there is now a contract between you and me. Not you and the general public. Now it's you and me. And that individual that you send that to, especially if it's a judge, he's going to know that if he screws up one bit, you have a right in contract to go against him. Don't worry about civil rights laws. You have a right to go under the contract laws of this state. You may even get to use arbitration, which is even better. But they are trustees. Every one of them are trustees. And trustees, yes, there's a code section down there. I think it's 45 that deals with public officers. But there are also other laws under contract laws, under trust wills and estate laws that cover actions of trustees. So you got
That's Title 53.
Title 53. Thank you. Thank you. So keep in mind, and I've said this many times, I don't know that I've said it to y'all, but over the years of my engagement with this hard mistress called the law, I cannot for the life of me think of one problem that any citizen has or can have for which there is not a remedy somewhere in the law. The trick is, of course, finding it. But anyway, enough of a diatribe on that. Let's see. There we go. Now, So that pretty much ought to cover, section 2, paragraph 1. And, let's see. Of course, paragraph 2, that's the objectives, of government. And, wait a minute. In addition to the, paragraph 2 addressing the object of this government that you have created. In addition to that, this paragraph also makes plain your right to regulate your internal government. And it also addresses your right to alter or reform. Now, I hope you can understand quickly, and I probably don't even need to be talking about this. But when you consider going back to Article 1, Section 1, paragraph 11 and 12, by the way. But when you consider and understand the full power, the full scope of the power of a grand jury, maybe these words will help you understand why the grand jury is there in the first place and why it is as powerful an entity as it is. Because I can assure you this, your form of government as it currently exists can be entirely reformed. And it can happen with one grand jury, one fully informed grand jury. And your entire state organization can be changed overnight. That literally can happen. And I'm going to prove it. I'm going to prove this to you. I'm going to give you a homework assignment so that you can understand what I'm talking about. I want you to think about back in 2010, Congress passed the Affordable Care Act. And in that piece of legislation, there was a provision which instructed the Internal Revenue Service to make all employers known, make it known to all employers, if there is a member of your workforce who does not have insurance, who may not want insurance, who is not paying any insurance premium, you are to withhold X number of dollars every week from his paycheck, or every 2 weeks, or however often they're paid. Now, the first question that comes to anybody's mind, should come to anybody's mind, is, was that a constitutional provision? Well, actually, no, it weren't. Because it took property for a public purpose. And it did not give just compensation. That's the Constitution of the United States. Did your states object to the federal government doing that? No, they didn't. Well, if they didn't, why didn't they? After all, the 14th Amendment, Section 1, Clause 2 says that the state will not enforce any law that steals my money. But not one state exercised their authority on your behalf, or if you weren't the one whose money was being taken, your neighbor's property who was being taken, The state never raised its finger one time to defend from that unconstitutional provision. Now that, ladies and gentlemen, is a hell of a commentary when you stop and think that every legislator who passed that law sent it to the president, and the president who signed it into law, and the states who bowed down and did not defend you or your neighbor, all became unindicted felons, every one of them. Okay, so what? They did it, they got away with it. Well, no, they ain't got away with it yet. Why? Because that theft, that magnitude of that theft has not yet been presented to a grand jury. Not in any state. And it's only going to take one grand jury to find out what Congress did, what the president did, and what the states did for a flurry of indictments to come sailing out of that grand jury, taking out the vast majority of the members of Congress, removing a president, a former president, excuse me, and any state senators and representatives, governors, or attorney generals who happened to have been in office at the time. Don't tell me a grand jury can't change the complexion of our government, either in this state or in this nation. They can do it. It can be done. And that's why I often refer to the fact that the grand jury, once the evils become unbearable, the grand jury is the place first we turn. And should that fail, then and only then do we make a choice between tucking our tails and going home, shutting our mouths and hoping for tomorrow, or we reach up above the mantle and take a death grip on the Second Amendment. I think that's enough said on that. Now, let's try to get a little bit further along here. And so that takes care of our origin and the objectives of government. Now here is a paragraph 3 deals with the separation of powers. And as a sidelight on the separation of powers, which basically is holding, and you can read the language, that the legislature won't do the job of the judiciary won't do the job of the executive won't do the job of the legislature or the judiciary, and that they're to remain separate and distinct entities of governmental action. Well, it might be of interest to you to know that there is currently a case pending in the Ninth Circuit. And that case involves 2 Oregon state senators and a physician who became disturbed about the corruption in the information they were seeing coming out of Washington and official government sources during the COVID pandemic, or it may turn out to have been a plandemic. Whichever. They wanted to take their evidence to a federal grand jury. And the way they started it initially was they used a federal statute, 18 U.S.C. 3332, which tells every United States attorney in the nation that if you are requested to make a person's complaint known, a criminal complaint known to a grand jury, you shall do so. And all 94 United States attorneys did not comply with their oath of office. So the next thing this two congressmen and this doctor do is they go to the district court and they said, hey, judge, we got some information. We want to put it before the grand jury. Now, I'll have to admit, they didn't do that petition to that judge properly. They made it in the context of we versus them. In other words, they created what appeared to be on its face a case or controversy. Well, actually a controversy. It was not. The judge, upon receiving that and reading the nature of their complaint, should have understood that their pleading was improperly drafted. And he should have issued his order saying, this is an improper way to do this, to ask for judicial assistance in getting to a grand jury, and therefore I'm dismissing this petition without prejudice. Which means that would have been his way of saying, you need to bring it back to me as either an ex parte pleading or an in re pleading, but not as a controversy. But they didn't do that, and he didn't do that. But what he did do was he ruled against them. And in ruling against them, what he did was he went back, just like over 1,000 and something other judges have done in the last, what is it now, 40 years? About the last 40 years. They went back to a 1960, late 1960s case, Justice Thurgood Marshall. And Justice Marshall was talking about a lady in Texas who was trying to force the district attorney to prosecute her ex for not paying child support. And everybody knows that a citizen cannot force a district attorney in any state to engage in a prosecution. That is the sole discretion of a prosecutor to look at a case, look at the evidence, the weight, the relevancy, and the sufficiency of the evidence, and decide, yes, I can successfully criminally prosecute this, or no, I can't. Or it's a crapshoot, whichever way. And best just not touch it. That's prosecutorial discretion, and we as citizens cannot compel that district attorney. What we can do, and what Justice Marshall did not mention, is if we disagree with the district attorney about prosecuting the case, we can take it to the grand jury. We can ask the grand jury, can you find probable cause? Can you identify an offender? If so, will you indict or present this individual to trial? But he didn't go into that. None of them want to go into that. Nobody wants to go into that, because the problem with the grand jury is you can't control the grand jury. If they are fully informed, they understand the true nature of their power, the scope of their power, they cannot be controlled. And everybody in government knows that fact. And if a grand jury ever gets into a runaway state, you're going to have to get ready to go back to the Pope. But at any rate, what that judge did was, not only did he say, you don't have a right to prosecute or not prosecute anybody. That's what he said. But that wasn't all he said. He just basically just came right out and said, no, you don't have a right. You don't control the U.S. attorneys. Now, the problem with what that judge was doing was he was interjecting his personal assessment into a case that belonged to the decision of the grand jury. The grand jury is another court. It is a constitutional court in both federal and state jurisdictions. And as a court populated by a tribunal of judges, they have to make their decision when it comes to questions of probable cause and ferreting out crimes. It is their decision, not the Article 6 or the Article 3 judge. But that judge crossed the line in the separation of powers. And that is something that even today, even in our state courts, we have to be on guard against, because we have judges, we have district attorneys, and we have the aid of sheriffs and their deputies in stopping you from getting to a grand jury. The only reason Beth Maggioroni got to a grand jury was because she showed up at the grand jury at the courthouse the morning the grand jury was being assembled, and struck up a conversation with a gentleman. They were out there waiting for crowds to disperse and what have you. And one thing led to another, and he found out she was wanting to go to the grand jury, and she had her stack of her information, and he showed her his badge. He said, "I'm a grand juror, I'll take it in for you." Well, okay, here you go. And sure enough, her case got inside the grand jury door, and she got subpoenaed by the grand jury to come back and explain all of that, explain her side of the story. That's something that none of us have had access to. And now it looks like she's going to have to go back for a grand jury contempt against Mr. Wooten, because he ain't doing what the grand jury told him to do. So it is imperative to understand the necessity of every government agency staying in its lane. Don't go crossing the boundary lines between your legislative function, your judicial function, and your executive function. It don't work. This leads to it just leads to a mess. So anyway, I hope that helps y'all understand the necessity for the separation of powers. And so we can, I guess we'll move on to, well, let's see, paragraph 4 dealing with contempt. Paragraph 5, oh yeah, what acts are void? Okay, now there's another provision you need to know. Kind of funny, they're talking about acts in violation of the Constitution and the United States, Georgia and the United States being void. But then they jump right out of acts void, what acts are void, into a paragraph D, and they start talking about sovereign immunity. Now, this one is also, it's imperative for you to understand the concept of sovereign immunity. Sovereign immunity first raised its head in the Magna Carta, and I think it was like clause 56, 58 through 61, somewhere right in there. King John signed his name to that document, and it said that if any of his subjects be deceased, that is, their property was taken or their liberties were denied them, then the 25 knights, by the way, that's the grand jurors, that's where they got started, will use all their power, and they did, and that phrase is in there, all their power. You got to understand, you're talking about a group of barons who have men at arms, swords, shields, spears, horses. So King John knew very well what he was saying when he said all their arm. So he knew. But anyway, he said, take it to the courts, take it to our courts. That's when King John waived his sovereign immunity, when that immunity would have obstructed a remedy for the unlawful taking of property and the unlawful taking of your civil rights. Well, guess what? We had to go through a civil war for those, for words that mean exactly the same thing to get into our Constitution. In the 14th Amendment, Section 1, Clause 2, no state shall make or enforce any law. Any law. That means criminal laws. That means tort laws. That means civil contract statutes. All laws. No state shall make or enforce any law which abridges the privileges and immunities of citizens of the United States. 800 and some odd years it took for those words to get into our Constitution, but they're there today. Now, sovereign immunity, yep. It is a fact. It is a claim, and it is an affirmative defense to most any action, but it is not a defense, and the state of Georgia has waived it with the passage of that 14th Amendment, Section 1, Clause 2. The state of Georgia waived all of their immunity when it is your liberties that are being deprived, your property and your liberties. But at any rate, you can read, you don't need me to go through the litany of actions that can fall under the influence of sovereign immunity or its waiver by the use of insurance to cover their errors and omissions that may have deprived you of property rights. Oh, I'm sorry. Tanya.
Yes, Judge? Yeah.
I'm sorry, man, we're way over here. I've got to hush. I'm sorry.
Well, we're good. So if anybody has any questions for the next 50 minutes.
Yeah, I do.
Go ahead.
Just when Judge Nally, when you were talking earlier, a little while ago, and you mentioned that the case that was in the Ninth Circuit, and you quickly mentioned a statute that you said 18 USC and then some other numbers. I didn't get those numbers. Could you?
In that case, 18, well, let me just run through the litany. In Title 18, you'll want to write down 1504, 3332. You'll want to make a note of 28 USC 1861. Primarily, those three are the ones that guarantee. Oh, and federal rule of criminal procedure number 6. Now, if you'll read those, you will understand that the only authority that a sitting U.S. District Court judge has when it comes to assembling a grand jury, summoning a grand jury into his presence, The only thing he can do is consider the public interest. He can't consider anything else. Absolutely nothing else. But this judge did. He took on 2 or 3 issues, and he never once addressed whether or not their getting to the grand jury was or was not in the public interest. So that's the question that's going to be in the Ninth Circuit.
Thank you.
Another question. If not, we'll stop burning up the airwaves, burning up the internet connections.
Colleen has a question.
Who does?
I do.
Colleen?
I wanted to see on this paragraph 6, it says civil authorities shall be superior to the military. Is that always the case?
Always, without exception.
Great, thank you.
Always, without exception, unless you knew there had to be another shoe to drop, didn't you?
All right, let's hear it.
Martial law. If we are invaded and defeated or subjugated, then martial law will take precedence.
Thank
But,
you.
but after
Judge-
conflict in war, civil authority always is above military authority.
Amen, Judge. And then shouldn't you also add, or I know I'd like to hear it, that only in the places where the conflict is occurring is martial law to occur there. It does not blanket the whole nation.
That's true. That is true.
I yield. Thank you.
That is the only place it should be permitted. But now you got to understand, that's the difference between a civilized military operation and some idiot imbeciles and morons like the Germans or the Russians or
Venezuela.
back in earlier days, or Chinese back during their earlier times. You really cannot expect a military force in the world today to maintain much of a degree of civility.
Judge Nally, I don't know if you know much about property taxes. You know, I just hear you mention property a lot and protection of property, but one of the things that I've been hearing some about lately is that it's unconstitutional. Actually, it's unconstitutional for us to pay income taxes as well as property taxes. I know there.
Actually, no, it isn't, but go ahead.
No, it isn't. Okay, well, that's actually what I was wanting to know. Is it unconstitutional to charge income or property? And I think.
But let me explain, and I'm not going into any depth. God knows this subject. This subject can take up a week, so I'm not going there. But briefly, what you need to understand is you have a deed to your property, your home and your yard, front yard and backyard. And you believe in your mind you own that. Well, the problem is you don't own it. You own nothing. What you actually have is better described as a usufruct in law. You are, in the old English terminology, you are a riot tenant, and that is spelled R-Y-O-T for any of you that want to look it up. And you are a tenant of the United States of America. They are the ones who own all property. I'm talking about that shirt on your back, the shoes on your feet, but you have a right to the use of them as if you were the owner. And I'm not going to go into that any further, just trying to help you understand why you have to pay taxes. You're renting your property from your government.
Okay, thank you.
Nancy?
Did you call on me?
Yes, I did. Your hand is up.
Yes. I have a question about the Georgia Constitution. Is there anything in the Georgia Constitution that says that these election boards and these registrar boards in all 159 counties are negligent because these issues of voter rolls, the issues of the computer machines have been around 15 years and voter rolls 100 years. And they don't put it on their old business. It seems to me, people are talking about, why do we only get 3 minutes to speak? Well, we have to repeat all of these things that Haldeman report, et cetera, et cetera. It should be the election board that is calling Dr. Haldeman to them and asking them these questions, and they're being negligent and not discussing it. And they go to a person who has been declared by a judge as less than credible. And they're saying we should just listen to this less than credible person. But they're the ones that should have had this on. I noticed that this is different from California. These boards don't have an agenda printed, and they should have old business. And this issue is old business.
Well, now.
And is there something in the Constitution to say?
So
They're
Nancy,
violating-
we're gonna get to the section of the Constitution that talks about the election. So since
Yep.
we
Oh,
don't
okay.
have a lot
What
of
section
time and
is
two
that?
more
I'll read it.
questions.
Yeah,
I'll read it.
yes, by all means, y'all do need to go read Article 2, which covers your votings and elections. But the problem is, and to try and give you a down and dirty quick answer, the legislature has not told these boards of elections in sufficient detail how to conduct their meetings. Does that make sense?
Right.
Well,
Yes,
when
exactly.
when the legislature doesn't do it, whose duty does it become then?
The people.
Yes, ma'am, you're exactly right. The people. And if your board of elections is not going to sit down and develop a policy manual that tells them you will first take care of old business, then you'll go take care of something else. Then it becomes time for you and your group, your neighbors, to do something about it. And what do? Well, you can use the civilized process. You can go spend your 3 minutes and ask the board to, why don't y'all develop some decent policies and procedures governing your conduct? Please do that. And if they just keep turning a deaf ear to you, what do? Well, that's when you go to a grand jury. Ladies and gentlemen, let me tell you something about grand juries. If you go back and read some of the early case law in this state, and I'm talking about the early American and Georgia common law cases, you're going to find out it's going to occur to you eventually. Grand juries in the early part of this state literally ran the counties. Now, no, they didn't stick their hands into the business of the county every darn day. But if there was a road needing to be built, a road needing to be maintained, a tax that needed to be passed to get something done, the grand jury was consulted always. Commissioners did not touch taxes without first clearing it with a grand jury. And I'll hush. I'm sorry, y'all can get me on the stump so quick.
Charlene, your question?
Yes, Judge Nally, one thing that continues to bother me is everywhere we go where the public can make comments, we are faced with these 2 or 3 minute limits. I don't understand how that is constitutional. It
Well,
seems
it is. Let me just.
Constitutional for them to do that?
Yeah, let me go even further. They don't even have to give you a public comment section. They don't.
Where is that stated?
These boards, well, apparently it's their own policy and procedure. Now, the problem comes when they do permit a policy, when they, well, let me give you an example, one I do know about, Cobb County. Cobb County does have in its ordinances a provision for the commissioners to allow a public meeting, and it sets a limit, but for each speaker. So they have to comply. They got no choice. But a commission in this state, unless it's mentioned somewhere in the, and for the life of me, I can't remember whether it's, I think it's Title 45 that deals with ethics for public officials. There might be something in there about public meetings, but otherwise, they don't have to open their doors, or they can open their doors and should open their doors for public meetings, but they don't have to allow a public comment section or session within that time frame that they have set for their meetings.
So how do we address our First Amendment rights, that we have the right to petition for grievances? Where does that come into play? Because we have that constitutional right.
That you can do. That you can do to any agency of the government. You can
Well, that's
petition
what I'm
to
saying.
the government and to address the board. You absolutely have that right, and then they have the duty to comply.
Well, I understand, but that's what I'm saying, Judge, is that if I have that right, federal and state, how can they limit my right to petition my grievance?
You didn't file a petition. You just showed up at a meeting and took whatever time was allotted to make a statement. Now, what you can do, even if they say, let's just say the Cherokee County Board of Elections is having a meeting and their policy requires them to have a session for 5 minutes. And you know for a fact that it's going to take you 15 minutes to get through the details. What you can do is not use their 5 minutes. You can submit a petition to meet with the board, and for the purpose of presenting your remonstrance.
Special meeting?
Yes, a special meeting. You can request that. You can petition them for that purpose. And not only that, but you can also request that the attorney for the board be present.
But we can't say that it's public. It doesn't fall under the public portion of any of their meetings. It's a separate private meeting.
No. You can request it to be a part of their public meeting. You can request them to make it a separate part of their agenda.
Okay, I'm talking to you soon in about a week.
Yes, dear. He who
Okay.
must, the voice of she who must be obeyed.
Yes, you must. Hey, Sue, you're up.
Hey, this is going back to the eminent domain. I was listening to another group today that said that the Supreme Court had made a decision on, I can't remember the name of the person, but anyway, somebody had filed to the Supreme Court that they had taken condemned their property and took it away from them for purposes of private industry, and that the Supreme Court actually had changed the amendment in the Constitution to allow that. And that is something that, how does that fit with what we have in our Georgia Constitution? How do we overcome the fact that the Supreme Court has allowed that, and it's actually being perpetrated on other states, that if a private company comes in and wants to utilize, say, for instance, farmland to build a pipeline through their land, that they have the right to do that? How does this compare to what we've got in our Constitution? How would we fight that?
Okay.
Because our Constitution says it's for public use.
Okay, so I'm gathering that you've read Article 1, Section 3, Paragraph 1, right?
Mm-hmm.
Okay. Let me let me make a suggestion. One of the links in that notice that Tanya sends out is the link to scholar.google.com. And if you will go to there and type in the search term eminent domain in parentheses, and then drop down to the 3 little radio buttons and click on Georgia law, that will bring up any cases in Georgia law back to about 1950, I think. Maybe, yeah, about 1950. And you can order them in date sequence, the most recent first, and you can scan those and read each of those synopses under each case heading, and see if you can find one that addresses specifically the question that you have. But now, of course, I don't know whether is your concern with state eminent domain or county eminent domain? County,
State, our state, and what we have here, saying it's required for, public use, that they can offer, compensation to take over.
well,
But what I'm saying is, go ahead.
well, the public purpose phrase applies both to the state and to your counties. Your county eminent domain is covered in the Constitution at Article 9, Section 2, Paragraph 5. So you might compare those, but there should not be any significant difference, and there certainly isn't when it comes to a public purpose. Both of them are required to contend with a public purpose. Now, it is possible that you may have a corporation, a corporation which is both public and private. A private corporation performing a public service. There might be some cases where that kind of a question has been addressed, but just to allow a private corporation to take property and then use it for nothing but private gain, no. To my way of thinking, that does not comply with our constitutional provision in either, whether Article 1 or Article 9, it doesn't matter.
All right, are you good, Sue?
I hope that helps.
Yeah, that's fine. Yeah,
All right.
thank you.
You're on, Michael. You got the last question.
Okay, thanks. Going back to that thing about Article 1, Section 2, Paragraph 6, the superiority of the civil authority. You're saying that that's true except for martial law, right?
Yes, sir.
Now, by martial law, do you mean emergency powers as per Title 38?
No. Martial law would can only come through an act of war or insurrection, and that's just so far-fetched.
Oh, okay. So in other words, like what I'm getting at is the pandemic that we recently experienced, where they had the governor had emergency powers. In my understanding, my question is to confirm that I'm thinking right about it. In my understanding, he does not, the governor does not have the right when he has emergency powers. This is, I guess, not a martial law situation. He does not have the right to override the Constitution.
No, he does not. You're absolutely correct.
Right. So in other words, they can't say, hey, there's a pandemic, so everyone has to get vaccinated and there's no choice, or something like that. Because that goes against our rights. So he doesn't have that much authority, even.
I don't care, short of an act of war, there is nothing that will suspend the Constitution. You will comply with it. I don't care how many people are dropping dead around you from COVID.
All right. Well, that's good to know, because I think that's a scenario that we got awfully close to, and that could happen again. So it's good to know that.
Actually, yes, we did, didn't we?
Yeah.
Our public officials went a bit too far.
And I'm sorry, this is here. I know that we're out of time or well over time. And I will say maybe for next time, can we talk about that? I listen to a lot and I hear a lot, and I know that there's going to be another pandemic coming up, likely 2025. You see all those people that were being arrested for not wearing masks, for, being out in public, not being 6 feet apart, whatever it may be. Another mandate's coming down because they want all of us to be vaccinated with the nanotechnology. But I would love if we could have a future conversation about that, because I think that's going to be something that we all need to be very aware of.
That very information is what the case in the Ninth Circuit is about. Additional information from the time those two senators and that doctor started that case until today in the Ninth Circuit, the evidence has grown exponentially that more people are being killed by the vaccination.
Yeah. So I can send you these names, but have you heard of Karen Kingston and Dr. Anna? I'm going to get her last name wrong, but Masheki?
No, ma'am, I'm sorry. Those names.
Okay. I don't know if you have anything to do.
It's Mikovits.
Is that it? Okay. They are authorities on this nanotechnology, and they have a lot of good information, and have actually been begging to be called in as expert witnesses. But of course, nobody will.
You can rest assured that with this doctor and those two senators and Oregon senators, there's going to be a lot of people getting subpoenas to federal grand juries. If they ever get to set their foot in a grand jury door, there's going to be a lot of people called for witness.
Quick note to follow up with Tara, or to follow on what Tara's saying. Karen Kingston has a Substack. You can get a lot of the stuff for free, or you can pay for it and get a bit more. Her stuff is fantastic. She's done over 10,000 hours of research into this, and yes, it's a death shot. I also recommend you check out Dr. Mark Bailey's Farewell to Virology, and it's a website called Virology as well. It goes even deeper than this. Yeah, it's amazing. It's an imaginary concept, viruses are. I know that blows people's minds, but you can take it farther if you'd like. They don't even exist. But check out Karen Kingston. She knows this, but her research is fantastic. She used to work for these people. Check out her Substack. I yield.
Okay, thank you. Okay, Tanya, what do you think?
I think we can call it a day. Thank you, Eric, for that note. And thank you, Judge, so much for the day, and everybody for your patience. I need to figure out what in the world happened with the link.
It only happened to 3 or 4. It didn't happen to everybody. So,
well, it happened to quite a few people, I think.
Yeah.